Brian, how does a revocable living trust differ from the irrevocable living trust beyond the obvious?
Yeah, the obvious is one is revocable, one isn't. But it goes way beyond that. The revocable living trust is generally something akin to a will. So you can have a will that sets your everything, upon your passing. You can have a revocable living trust. The difference between those two is that a will generally mean you've got to go through probate. And depending on your state, this may or may not be a very difficult task, but you will have to go through probate. You got to get the court to approve things. You got to put public notices out. There's a period of time. You have to wait to transfer ownership of assets. So with a will, wills are a great first step, no question. But if you want to avoid probate, then you would go to a living trust. And irrevocable, you can change it, is what that means. You actually set those up in your Social Security number. They're not a separate entity. That's another difference. But with an irrevocable trust, that's a whole different animal. That's its own entity. That's something where you fund it for a particular reason, and those reasons can vary, but it's not something you can pull that money back. You can't fund an irrevocable trust and say, you know what, I changed my mind. I did have this trust set up for a charity or for my kids outside of my estate or whatever. It's irrevocable, so you can't undo it. So make sure you understand what you're getting into.
Brian, can you give me an example of when you would use an irrevocable trust versus a revocable living trust?
Yeah, so let's say you have a revocable living trust instead of a will, and within that you have provisions to set up irrevocable trusts upon your passing. So you might say, all right, I want to put money away for my kids, but I don't want to give them all the principal. I'm going to when I pass away, money's going to go into an irrevocable trust, a family trust. And that trust is going to pay the income out to my children and maybe any amount for college education or first house or whatever. But they can't take any more principal out beyond that. Upon their passing, the money will go to the grandchildren or something like that. So that's a case where you're actually using both. You've got, or let's say during your lifetime, you might say, well, I'm going to set up a charitable trust, and that's irrevocable, but I'm going to get tax benefits from it and so forth, and benefit the charity and not pay capital gains on something I'm selling. So you might set up an irrevocable trust that way. So there's a lot of, and the third one I see used a lot is within your revocable living trust. When you pass away, maybe half of your assets go into an irrevocable trust that benefits your spouse. And that's a way to save on state estate taxes or federal estate taxes.
Brian, who generally sets up these trusts? Do you need an estate planning attorney?
Yeah, you do. I would not advise you go on LegalZoom.com and try and figure this stuff out yourself. Your CPA and your financial advisor, I'm both, and I can't do that for you because I'm not a licensed attorney. So you need a licensed attorney to set up these trusts. However, I will say that the financial advisor you're working with, if it's my client, I know their situation. I'm kind of coaching on what makes sense and what I've seen and what works, what doesn't, the benefits and detriments to each decision, and working through that before you go to the attorney to actually have the legal documents sometimes obviously makes a lot of sense.
So you can advise the client, but when it comes to signing the legal documents, that's where the estate planning attorney comes in.
Yes.
Brian, thanks for telling us more about the difference between a revocable and irrevocable living trust.